All right, with that, we'll turn to the third case on this morning's docket. That case is case number 127790 from Johnson County, State of Kansas appellee versus Daniel Michael Marschall, appellant. Would the parties please state their appearances?
Please court appellant Daniel Marschall appears by counsel Kate Zigma. I'd like to reserve 5 minutes for rebuttal.
5 minutes are granted.
May it please the court, your honors. My name is Maria Davies and I represent plaintiff appellate state of Kansas. Mr. Minahan wrote the brief, but he's unavailable.
Ms. Davies, have you entered your appearance in this matter?
Yes, your honor. It was in June of 2026.
Excellent. Thank you very much. With that, you may proceed.
May it please the court whenever y'all are ready. This case seems kind of new and interesting and exciting, but the reality is there's no new law here. There's no new exciting law. It is just Edgar. It is just Strickland. It is just Lafler and Fry. The twist comes because we have a different procedural point in time that we're looking at this analysis. And because frankly, no one's ever talked about KDOC classification in this kind of context before. So the biggest part is where the district court went wrong is one, this should have just been in Strickland. I can try to bootstrap my way into knowing involuntary, but it's a Strickland issue. This is a competent counsel issue. And the reality is there was this not uncommon, but not common in the case law situation of we had alternative plea bargains offered. And so this is the unique facts. The critical point is advising the client when choosing between the alternative plea bargains. This is different from all the other motion to withdraw pleas where they ended up going to trial and got the full boat or whatever. But when you have to choose between two plea bargains, then that's where the reasonable investigation, which is a key Strickland part of any kind of Strickland analysis.
Counsel, it looked to me in reading the record as though Mr. Marschall was singularly focused on probation versus prison. Is that accurate?
Judge, I think that the court could read the testimony that way, but they did also talk about they wanted to look at work release. The state wasn't going to go there. And I think that comes back to sort of a core function of being defense counsel. Our clients want a dismissal. They want an acquittal. They want, the stars and the moon and the state to pay for them and all their trouble for having to retain an attorney. I quoted the Rolling Stones, but that's the moral of this case. You can't always get what you want. And so it's one of those things where a defense counsel has to work with their client to tell them, I know that's what you want. This is what you need. And the problem with Mr. Marshall's case is he didn't know he could get what he ultimately needed, which was he wanted to keep his job. He wanted a minimal interference with his life. And the reality established by the remand hearing is that if he had taken this prison plea bargain, the district court find more likely than not, he'd be minimum security, and more likely than not, he'd be going to work release.
One of the things that I've struggled with here, first of all, how can we require defense counsel to know all of these ins and outs when I'm reading them and thinking this is very difficult, but also how it's still just a likelihood.
Well, what I would say is I understand the court's point, but that's really the position defense bar was in when Padilla came down. None of us knew anything about immigration. And all of a sudden we had to start learning about immigration and telling our clients about immigration. And this is slightly different because usually defense counsel is like, hey, go talk to Sharma Crawford or an immigration attorney. Like go talk to somebody who knows what they're doing and then come back and tell me what they said, or I'll call them and they'll tell me what we got to do here. There's no one like that for KDOC. The only person who could be like that for KDOC is the defense bar. I mean, who's supposed to know this stuff besides the criminal defense attorneys and the prosecutors and, DOC? So that's the difference.
I have a question kind of going down the Padilla road. So the way I was looking at this, if you're looking at ineffective assistance, we have a number of decisions like McCauley, Moody, Wilkinson that say, counsel has a duty to advise of direct consequences, but not collateral. And the way I read Padilla is like it's saying deportation is kind of its own category. Like you can't call it collateral, you can't call it direct. So why would the consequence here, with the classifications of KDOC, why would that fit into a direct consequence?
I think the court is kind of making the same mistake the district court found. We're not looking at the point once we enter the plea and before you sign that dotted line and say guilty, you are fully aware of what your consequences are. We're a step before that. We're picking between the two. So we're back in a reasonable investigation level, sort of like, why didn't you call an expert? Why didn't you present this witness? It's a step back from that, which distinguishes it from those situations. And most of the time, this isn't going to come up. If the option is plead as charged or plead to this amended charge and go to your guideline sentence, okay. I mean, it's going to change your sentence duration. It'll change your charge. It'll change you from, presumptive probation to presumptive prison, whatever the case may be. We don't have to go to that second level. This second level had high risk, high reward for the one, and the client, needed to know this was high risk, high reward, but there's no appeal and there's nothing we can do if we don't get this. But there was a second option that had this other layer to it that really made it the more appropriate plea for a low risk, a low risk, medium reward, I guess. But I mean, in my experience, no district court's going to say, oh, level 9, go do your time is the agreement. Okay. I mean, they're signing that line every time. So that's the difference here, is it's not a question of did he know when he was entering the plea about the consequences of that plea? It's that he didn't have the information to choose that plea.
What kind of information? I mean, I know what information we're talking about here, but how do we assess that? If we open that door, how do we assess what information needs to be provided and what doesn't? I mean, that feels like that's a very difficult way to go down.
I understand what the court's saying, but that's why the investigation standard is what it is. It's reasonable limits on investigation based on reasonable investigation. It's no different than anytime we take that standard to a trial, which is always going to have its own facts and circumstances and players, because even though you could say the general rule is you have to have an expert if the state has an expert at trial, maybe not. I mean, it's all going to depend on the facts and circumstances. And that's what it is here. It's not a new law. It's that you have to have all the facts and circumstances to make your client or allow your client to make this decision. And that kind of comes down to the other thing is all of this information was publicly available. And the classification is almost a static instrument. It's like, what's your criminal history? Did you ever have an escape? All things in the PSI, all things you can get about disciplinary reports calling over to the jail, all things you get from talking to your client. And so it's not like we're asking you to predict the outcome of a psych eval. We're not asking you to predict what a neuropathologist is going to say. What you would have to advise the client is pretty much exactly what I said in my brief. Look, DOC, maybe they give you an exception, maybe not. They don't usually do that based on what I see. This is what I think is going to happen, but I can't guarantee it. And that kind of leads me to the Bricker issue. If my client had been advised of the work release minimum situation and gone that route, and then whatever happened at DOC that it didn't happen, I think that's when he's like Bricker, because we can't control DOC policy. But I do think it's a reasonable investigation and a reasonable thing to require that attorneys advise their clients about what they're looking at in the future to the best of their ability. They can't say it's for certain. If they say it for certain, then we're kind of back in normal plea territory or withdraw plea territory. But that's the point of attorneys. One of the things that stood out to me in the state's brief is they said, well, the district court wouldn't have to go through this. And I agree. But why should defense attorney? Well, that's our job. That is our entire job, is to make sure that you know all the things, all the information that you should reasonably have to make your decision. And if we're just going to go with, all that you have to tell you is what the court has to tell you, why are attorneys there? I mean, the court's going to tell you what your max is. The court's going to tell you what your guidelines are. The court's going to tell you your trial rights. It's that critical point where when we're making those behind the scene decisions, we have to give them enough information to make their decision. And that's where I think we go astray here.
Is the thing that puts us in Strickland versus Edgar, I mean, whether there is a meaningful difference between those two is perhaps debatable, but there's a thing that puts us in Strickland, the fact that this is an alternative plea deal.
I think it is, because let me back up. Edgar basically says, once it's post-sentencing, we're applying Strickland. I don't disagree with that. I use the phrase deficient performance because that's something we use on the ineffective assistance of counsel side all the time. That's not a different standard. That's just the reasonable performance standard. And so I've lost my train of thought, but
So let's talk about, what would have been different. So if he would have been given this information, what would have been different? Would he have given up the opportunity to argue for probation?
yes, he would have given up the opportunity to argue for probation. And he testified that he would have rather done this. The unique thing about this case is this client figured this out in RDU and went, what in the world? If I had known this, I would have made a different decision. This isn't some attorney came up with an idea a minute, like, hey man, if you knew this, would you have done something different? He was shocked when he learned this because this is what he would have chosen. And he testified to that fact. The district court didn't, the district court focused on probation and he wanted probation, but we're back to the stones. I mean, you can't always get what you want. And I don't think the district court ever really made any sort of factual findings about, well, if he had known this, he might have gone for work release. The district court was kind of stuck at the, when you entered the plea to go for probation, you knew you wanted to go for probation. And you've got to back it up a step. Because all of these kind of ineffective assistance cases are, I call them choose your own adventure books from the 80s, right? Like you read to page 15, it says, if you want to go left in the cave, you go to page 42. If you want to go right in the cave, go to page 53. And that's what this is. You have to back that up in time and make those decisions there because it changes the route and it changes those decisions along the way. If the court doesn't have any other questions, I'll reserve my comments about Lafler and the remedy for rebuttal, except to say that I'm pretty sure Lafler, clear as day, says that if we have to purge the constitutional taint. And in this case, the only option to do that is to vacate the conviction sentencing and then go forward with the other plea. I'm asking my client to go to prison just for a different charge for a different amount of time.
All right, thank you.
Thank you.
Counsel, good morning.
Good morning. May it please the court, Plaintiff Appellee, State of Kansas, Maria Davies. So Marschall made a calculated strategic decision to choose the severity level 7 plea to gamble for probation, and he deliberately rejected the level 9 offer that guaranteed prison time. And having lost that gamble, he now seeks to withdraw his plea by conflating discretionary prison administrative policies into constitutional error. So the first prong going to discuss is that counsel in this case had no legal duty to advise on collateral discretionary prison policies. Due process only requires advice on direct consequences, those that are definite, immediate, and largely automatic. And KDOC classification, I'm going to go through KDOC classification and work release policies, but those are both highly subjective, multi-tiered, and non-automatic. There's subjective overrides, there's physical constraints, and there's fluid rules. And those were outlined very much so in detail in volume 7 and volume 10. Going through a couple of those, even with an initial minimum security classification, an inmate may still be placed in a high, medium, or high levels of custody, and that's depending on bed space. Defense counsel would have had no way to predict what the bed space would be at KDOC.
Counsel, as I interpret opposing counsel's argument, it's not that the attorney had to provide the exact what exactly happened, but had to at least provide some information so the defendant could meaningfully distinguish between what these two options look like beyond high risk probation versus this other option. Are you interpreting that differently?
So Your Honor, I think something important to consider is that Marschall clearly testified at the Van Cleve hearing that he had wanted probation. That's also what Lewis testified. So the goal really in this case was probation. I think it's also important to note.
Was there any testimony, though? What I really wanted was probation, but this would have changed my calculus.
So in hindsight, Your Honor, in volume 7, Marschall does testify that if he would have known about this, that he would have likely accepted. So that really goes to, Your Honor, I think that Marschall cannot show Strickland prejudice, even though Lewis did not have the duty to go through this with him because it was not a direct consequence. It's important to note that his strategy was to avoid prison entirely. And he cannot show a rational probability that he would have objectively accepted guaranteed prison time merely for minimum classification or work release. Trial counsel confirmed that Marschall wanted probation, and Marshall's own testimony at the Van Cleve hearing was really illustrative of that. He said he was scared of prison. He viewed it as unsafe. He even had obtrusive thoughts about it.
Since we, we're talking about the Van Cleve hearing. That's part of the difficulty with this case. It went back to a Van Cleve hearing, and it essentially was treated as a motion to withdraw a plea and using the Edgar standards. Do we have a finding by the district court on prejudice?
So, Your Honor, I think that in this case, it was important to note, and the appellant noted in the brief that they said that he would likely have got minimum classification, but the court also said that it was not a guarantee that that his classification wouldn't have been raised or moved up. And also it was not a guarantee that he would have got work release. So I think that the court addressed it in that way, that he wasn't prejudiced because there was no guarantees. And so that goes back really to the state's argument that these two different factors, KDOC classification and work release, there's subjective overrides, there's physical constraints, there's fluid rules. It's important to note that an intake investigator conducts a detailed evaluation and they analyze the resident's file, disciplinary reports, residents in the behavioral health unit, and the investigator's impression of the resident. And so that shows that there's so many unknown factors. And at the sentence—
There are many unknown factors, but there's kind of a presumptive route, is there not?
Your Honor, can you expand a little bit more?
That there, depending on the classification, that there's kind of, it's presumptively that someone is going to, with the plea and the conviction that Marschall has right now, it's presumptive that he will be in medium to high security. Whereas if he had gone with the other plea, it's presumptive that he would have been in a minimum security provision. And each of those have differences that are notable.
So a couple of those 6 factors, yes, Your Honor, are more static, such as the inmate's age when they enter into custody, prior criminal convictions. But something that was important to note about that initial classification was at the Van Cleve hearing, the KDOC witness did testify that Marschall scored 0 on the hypothetical institutional adjustment. But the KDOC witness also said that she did not have any information about how he behaved when he was in the county jail. So there were some things that were static. However, that's not static. We can't predict how his behavior would be in jail after sentencing or how he would behave at RDU. And then also, Your Honor, they testified that there's no guarantee that he would have, even if he scored the minimum classification due to space at KDOC, there's no guarantee he could have been classified upward.
And nothing in these trials is guaranteed. And so I'm just trying to figure out, if someone is, we require defense counsel to talk to their clients about potential sentencing outcomes when they're looking at a plea. But as we know, that sentencing outcome, even within the grid box, there is variation. And then, if they are asking for a departure sentence, then the counsel still has to talk to them about, here's the likelihood of a departure. Here's, the judge doesn't have to provide a departure. Is it unreasonable to ask for defense counsel to tell them a little bit more when you're faced with this kind of interesting and unique situation of alternative pleas?
So I think, Your Honor, going back to, again, counsel can't predict what some of these humans are going to subjectively believe or rule at KDOC, but going into your question more, he had testified that he wanted to avoid prison in this case. He wanted probation. So I think that this case is very different. If maybe defense counsel in a different case affirmatively misled him and knew that he wanted work release and tried to go through all these different classifications and said, yes, you're going to score minimum, you're going to get work release. So I think there's different situations where maybe someone would have the duty to do that investigation, or at least not affirmatively mislead. But that's very different than this case, because Mr. Lewis did not affirmatively mislead his client in this case, knew what his client's goal was, probation, and there's no way really that he could have predicted what these people at KDOC would determine.
If there are situations where it might be important to provide that information, I understand that it's your position that this is not one of those situations. How do we determine what those situations are?
So I think that would be more analogous to a case where they're talking about someone's criminal history and maybe counsel is completely wrong on the criminal history, or where they tell their client, yes, if you plead to this, the judge is going to have this outcome. But again, that's not what happened in this case, because he didn't affirmatively mislead. So maybe if Mr. Marschall had told him that he wanted work release and Mr. Lewis said, okay, when you go to KDOC, these are the different factors. They're going to classify you as minimum. They're going to give you work release. I think that would be a very different case.
But what do we do with Padilla?
So Padilla, Your Honor, I think as the court was discussing earlier, the state's position is that Padilla created a narrow exception for automatic deportation. And the state's argument is that does not extend to internal administrative prison classifications. This was not something obvious that Mr. Lewis should have known. In Padilla, I believe that the court ruled the deportation was something very obvious that trial counsel should have known and been able to advise the client on. So deportation is very different from work release and classification in this case.
So Padilla is just an immigration case having to do with deportation, and that's it.
Yes, Your Honor, because deportation is very unique, especially in this day and age. So it's different than the usual direct and the collateral distinctions. Something that also is important is at the sentencing hearing, trial counsel has stated that Marschall was diagnosed with bipolar disorder, generalized anxiety disorder, borderline personality disorder, and ADHD. And when asked at the Van Cleve hearing, the KDOC witness said a factor like bipolar disorder or mental issues that someone is dealing with would typically increase the classification, or it could remain the same. That's another unique factor in this case, Your Honor, where Mr. Lewis wouldn't have been able to predict how that would have played out. And then also it's important to note that about a quarter of the prison population gets an exception and is reclassified, and that shows that the system is highly discretionary. Moreover, the trial court can't order that someone go to KDOC and be classified a certain level or be given work release. And so I've been kind of focusing on the classification, but work release also is not definite, it's not immediate, it's not largely automatic. The eligibility requires that the inmate be physically capable of seeking and maintaining employment and maintaining behavioral health. Again, that goes to the facts of this case. Mr. Lewis would not have been able to predict if there was even going to be a work release program available to Mr. Marschall, and if Mr. Marschall, because of his needs, would have been able to successfully complete that, take medication. Also important, Your Honor, going to the physical limitations, same kind of as the classification at KDOC, a lot of this has to do with space. The KDOC work release has a capacity of 450 men. So Mr. Lewis would not have been able to guarantee that his client would be able to get work release.
And it was my understanding that those were across all of the work release programs in Kansas. Is that accurate?
I believe so, Your Honor. That's in volume 10, but I believe so, at least from what the KDOC witness testified to. It's not guaranteed. There's a specific number of bed spaces. And Lewis correctly stated that he'd be highly hesitant to advise a defendant about work release because, to use his own words, there's not a lot of wiggle room. And he had no duty to predict that KDOC, how it would exercise its control. Then I want to go back to prejudice. I know I spoke about it a little bit at the beginning, but again, his strategy was to avoid prison entirely. He cannot show a rational probability that he would have objectively accepted guaranteed prison time because trial counsel confirmed he wanted probation, he was scared of prison, wanted to resolve the case with as little intrusion into his life as possible. And the plea was also knowing and voluntary, want to touch that prong. There was no manifest injustice. Mr. Lewis explained how he explains to his clients open to argue and factors that helped and hurt Marschall in this case. At the plea hearing, the court also informed Marshall of his sentencing range. It included a maximum of 34 months with presumed imprisonment. The court, even on the record in volume 3, he reinforced that if his sentence resulted in presumed prison, the state would argue that he should serve the mid-box term in prison. And the court also explicitly asked Mr. Marshall if he had any questions about the plea agreement. So he entered into this plea knowing involuntary. He knew what the factors were, knew what he was entering into. There was no way that he could have guessed. There was no way his attorney could have guessed or the court could have guessed what would happen at KDOC. And so Marshall made a strategic gamble to avoid prison. One of the options allowed him to argue for probation. He lost that gamble. He now has buyer's remorse. Absent any other questions, I would ask this court to affirm.
Any questions? All right, thank you, counsel.
Thank
So I think one of the big points I'd like to start is I think there is, I didn't argue it in the first half, but it's in our brief. I think there is some mutual mistake here. The evidence was pretty clear that the state didn't want to give him work release. I don't think they knew they were kind of giving him work release with that level 9 go to prison plea offer. And the undisputed evidence is Lewis didn't know that he would probably go to work release. And that's that critical factor. If your chances are, when you're only told, hey, we can ask for probation, it's like, yeah, that sounds great. Or you can agree to go to prison and you don't know what prison is really going to be like or what the programs are going to be or that you're probably going to work release. That's a huge factual issue that most clients, that matters to them most. What does my life look like after this? I think there is, the state kind of tries to reweigh the evidence by re-arguing all this classification information. We had KDOC testify. KDOC said, this is what he would end up being. While there were some things we didn't know because he hadn't fully been classified, if my client had disciplinary violations over in the jail, I would be shocked that the state didn't march the jail on over to tell us all about all his DRs, because that would have spiked this argument completely. So they almost want us to prove a negative here. If they had information he had DRs that would have affected classification, I anticipate that would have been presented at our hearing because it would have spiked my argument. There is, it is KDOC policy, but Padilla is, immigration is all about policy these days, and we still have to advise them and we still have to look into these things. So I think that just because it's a KDOC policy versus a specific statute and unable to be ordered by the court, that doesn't really take us outside of Padilla. Turn on the news, that we have all these policy issues. I think part of the other issue is that the knowing and voluntary, where we talk about due process considerations, that's a separate factor. We have to stay in ineffective assistance of counsel.
That's an issue. That's, I think, something that's bothering me a little bit. So, I know this was filed as a motion withdraw plea. Normally that would trigger Edgar, but when you get to the sum and substance, it's an ineffective assistance of counsel claim. So how did the district court analyze that ineffective assistance of counsel claim under Strickland in its journal entry? Or did it?
They really didn't. And I don't know if this was some sort of hesitancy. Trial counsel is well respected here. I don't think that anybody wanted to label him ineffective. And so things got crammed into a different factor to try to skip over that part. But this is what this is. It's an ineffective assistance. It's a competent counsel claim. And even though the trial attorney here is very, very good, everybody makes mistakes. That's why we have motions to withdraw plea and ineffective assistance of counsel. So I think the district court erred by not doing that analysis. And that's part of why we don't have any real findings about prejudice under Lafler. Lafler at its heart was an error of law caused a rejection of a favorable plea. This is an error of law and investigation that caused the rejection of a favorable plea. But instead of going to trial, we picked the other plea.
Can you talk to us about the remedy?
So the remedy is pretty crystal clear in my mind for Lafler. Lafler says you have to purge the constitutional taint. And where that can be fixed by resentencing, you can just resentence. Where it cannot be fixed by resentencing, either because we amended the charges or some other criteria, something in the case makes it you can't fully restore the client to before the violation, the court can reorder to issue the plea. There's one I wrote it down. I did not cite it in my brief, but there is an unpublished Court of Appeals opinion which kind of rejects this theory that the district court doesn't have the ability to order the state to reoffer a plea. And I can submit a 609 letter for that following argument. But the Supreme Court says you can. The Supreme Court's pretty clear in Lafleur. This is what you should do to purge the constitutional taint. So I think that is the remedy here. We need to go back. We need to withdraw this plea, and my client's just going to plead to a level 9 criminal threat and go do his time. However, that time seems to shake out. And if he balks at that, then the court can always say, well, we did this so you could do this. You changed your mind at the last minute and vacate that.
And so explain to me, so like typically, if you grant a motion to withdraw a plea, you just go back to the drawing board. So the plea is gone, great. Some people end up going to trial. But so why in this case must the remedy be he gets to accept the other plea?
Because that's the only way to purge the taint. And I think that if, for whatever reason, if we got to the point where it's like, all right, enter your plea to a level 9, and my client says no, then the district court goes, you know what? I'm vacating that order because we did this whole thing on the premise that you were taking this plea and that was the violation. And if you back out at the last minute, we now, what are we doing? I think the court can say, well, I'm going to revisit my findings on this because you just backed out. I'm finding there's no prejudice and you wouldn't have taken it. And I think that's the appropriate remedy to navigate this. If my client doesn't take this plea, I'm going to be very upset, but it's his decision. And I think that's pretty much the only other thing I would say that I kind of noticed is having bipolar or some sort of mental illness. DOC manages mental illness all day, all day. I don't think that bipolar alone, if it's well managed and medicated, which there was no evidence this was not well managed, it would trigger an exception. But again, I'm kind of lured back to re-arguing the facts the district court already found based on DOC's own testimony that this is where we would likely have ended up. If the court has no other questions, I believe that's all I have.
All right. We'll take the matter under advisement. Thank you very much. I will request that you submit a 609 with that Court of Appeals opinion, and you'll have the opportunity to respond as the state per the rule.
Thank you, Judge.
The court will take the matter under advisement and issue an opinion as soon as we're able. Thank you to both of you and thank you for pinch hitting today. It's great to have you here. At this point, the court stands adjourned.